Welcome, ladies and gentlemen and distinguished guests. I'm Pip Nicholson, the Dean of the Melbourne Law School, and it's an absolute pleasure to welcome you all here tonight for the 2018 Public Law Conference, The Frontiers of Public Law. Before making any further remarks, I would like to acknowledge that we meet today on the traditional lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present. I'd also like to start by thanking most sincerely all of those who've been involved in putting together the conference. And in particular, I would like to recognise the work of our convener, Jason Varuhas, and from the University of Melbourne, and the Associate Convener, Shona Wilson-Stark from Cambridge University. I'd also like to mention the great assistance that was received from Mark Elliott in the early organisation of the conference. I'd also like to thank Assistant Parfit Tiratpan, a third-year DAD student who has been intimately involved in the development of the program, and more generally the students who are assisting today and over the coming days, and the events team also. Obviously, I need to thank our sponsor, Hart Publishing Limited, which has sponsored the conference series, and both the Melbourne Law School and Cambridge are clearly in Hart's debt, as I'd like to suggest is everyone else attending. The second Richard Hart Prize will be awarded at the conference dinner for the best paper by an early career researcher, and I look forward to hearing about some of those papers that were submitted later in the proceedings. The 2018 Public Law Conference is the third in a biennial series of clearly major international conferences on public law. This is the first of the series to be held outside of the University of Cambridge, and it may not come as a surprise to you that I'm simply delighted that it's at the Melbourne Law School. When founding the series in 2014, the conveners envisaged that the series would be an academic conference first and foremost, with the aim of fostering a dialogue on the key issues in public law between people from diverse common law jurisdictions. This is clearly a goal that has been realised over the life of the series, and this year we welcome more than 250 delegates, including 80 speakers, from more than 115 institutions spread across the globe. The participation of leading academics, judges and practitioners from so many jurisdictions is, I think you would all agree, a testimony of the recognition the conference role has and continues to have as a leading forum for the scholarly discussion of public law issues in the common law world. This year's theme, The Frontiers of Public Law, engages with a range of questions concerning both the boundaries within public law and the boundaries of public law itself. As some of you know, my research has been on socialist legal systems, the Vietnamese system in particular. In recent times, I have explored, and indeed some of the colleagues with whom I've explored these questions are present here this evening, issues around the location of power in socialist legal systems and how the location of power is changing, often indeed to shore up political power and legal power rather than to disperse it. As a community and as a global community, we live in very dynamic geopolitical times, and this in turn is producing new pressures on our institutions. When I explored this program, which Jason generously has been providing to me regularly over the last couple of months, I was reminded of the abundant intellectual energy and humanity that infuses the scholarship and the practice of public law in the common law world. I was also struck by the freedom to express contested views about how our institutions and laws might work better. The program over the next few days is, I think, an absolute testimony to the ways in which this conference enables scholars and practitioners to debate public law, including, and significantly, I think, including, a focus on the balance of legal principle with appropriate institutional design, and I leave you to advise me what that might be by the conclusion of the proceedings, and extending the conversation to cover issues of legal practice and also moral choices. I do wish you all the best in all your discussions. I'll be dropping in and out of the program, but I look forward to hearing where you land towards the end of the gathering. Like the previous conference in 2016, the 2018 conference also includes dedicated panels for doctoral scholars on both Thursday and Friday mornings. These panels cover a range of issues, and you can consult the program to be inspired, as I was. I also look forward to seeing many of you there at those gatherings, which convene at 8 o'clock in the morning, 8 o'clock tomorrow morning, I remind you now. It is a pleasure, once again, to welcome you all to the University of Melbourne, and in particular to its law school. Enjoy the days ahead, and most immediately, tonight's opening plenary session, The Frontiers of Executive Power. My final duty and privilege is to introduce the chair of tonight's opening plenary, Professor Carolyn Evans, who I am sure is well known to very many of you. Professor Evans is Deputy Vice-Chancellor, Graduate and International, and Deputy Provost here at the University of Melbourne. Carolyn is also my predecessor, the former Dean of the Melbourne Law School, an office she held between 2011 and 2017. Professor Evans is an internationally recognised expert on the relationship between law and religious freedom. She has degrees in arts and law from the University of Melbourne and a doctorate from the University of Oxford, where she studied as a Rhodes Scholar. It's an absolute pleasure, Carolyn, to welcome you.
On behalf of the University, and indeed on behalf of the Vice-Chancellor, who sends his regrets, he is unfortunately not in Victoria at the moment, to welcome you here to the University for this important and exciting conference. My particular thanks and particular welcome to those of you who've travelled from far across the world to be with us here today. Australians are used to doing conferences while half jet-lagged, and we always appreciate it when other people take the time to come to our side of the world and experience that as well. As Pip has said, this is just going to be such a stimulating, exciting, interesting and important conference, and indeed one that is incredibly timely. I'd like to thank world leaders who are kindly doing their best to kindle greater interest in public law and its importance. As someone who taught constitutional and administrative law for many years, in many countries at the moment, one could only say that this is a teachable moment. We are very fortunate to start our conference tonight with speeches from two outstanding and distinguished jurists, one from this country and one from the United Kingdom, the Honourable Kenneth Hayne and Lord Mance. And the Dean has embarrassed me by preparing a longer introduction for me than I have for either of our speakers, but I have to say that I was under strict instructions that at this conference we do very short introductions so that we can go to the substance. Each of our speakers will speak for 20 to 25 minutes, and there will be time for questions afterwards. Now, the brevity of my introductions, I should say, is no reflection on the distinction of the speakers. We could spend most of the night talking about their careers. But let me just briefly introduce our first speaker, Lord Mance, who has just retired as Deputy President of the United Kingdom Supreme Court after a very distinguished career as barrister and judge. Tonight, Lord Mance will speak on the frontiers of executive and judicial power, differences in common law constitutional traditions. Please welcome him.
Good evening. Thank you very much indeed. I think I have to start by saying that I'm not Lord Mansfield. Lord Mansfield appeared in the House of Lords once and said ruefully, I have no papers. That was because they'd been burnt down in his Lincoln's Inn Field house by the Gordon rioters, about whom he was actually, perhaps slightly oddly, speaking to the House of Lords. I have two papers. because when and if you see a published paper, you will see that it embraces a somewhat different subject from the one on which I'm asked to speak this evening, because it also includes relations between the judiciary and the legislature, which is actually quite an interesting area, and possibly the area where we've had more activity than in relation to executive power. But let me focus on the subject for this evening, which arises out of what Lord Diplock called perhaps the greatest achievement of his judicial lifetime, and that was the modern development of public law, a systemised and rationalised approach which over the last 40 years has shaped our practice today. But of course nowadays the Human Rights Act often gives judges in the United Kingdom an additional string to their bow, and in some respects a longer range string, because the interpretive duty under that legislation to read other laws compatibly with the Convention as far as possible has been treated as giving us the power to add, delete or rephrase words so long as we remain loyal to the general thrust of the laws. But leaving aside the Human Rights Act, we do also need to recognise an increasingly confident recognition of basic rights at common law, which has affected our public law. And of course the title of this conference, as I've indicated, looks primarily to relationships with the executive rather than the Human Rights Act power to treat read legislation compatibly. The traditional approach to executive action has been to focus on varies or legality, process and rationality in the Wednesbury sense. We were seen as common lawyers as reviewing executive action from the touchlines, and generally therefore as remitting any matter which had gone wrong back to the original decision maker for further decision in the event that the shortcoming was serious at any rate. Human Rights Act review takes place, on the contrary, within the framework of an increasingly detailed proportionality analysis, a fourfold analysis looking at the objective, its legitimacy, whether the decision was capable of promoting the objective, and finally, whether it struck a fair balance between the personal and communal interests involved. That final fourth head, I must admit to having had some reservations about its addition, but its addition is now firmly fixed. We noted in a case which is variously called Re G or Re P for mysterious Northern Irish reasons, the difference between proportionality review and common law review. The court is not so concerned with varies or process or with rationalisation by the decision maker, or indeed with whether the decision maker has thought about the relevant considerations at all. The court itself takes a view of the overall merits and decides whether the result lies within their parameter. And a good recent example of a case where we grappled with this sort of issue is, I think, Unison against the Lord Chancellor. It might be seen as straddling considerations. I'll come back to it in a moment. Going back to the proportionality analysis, the fourfold categorization of issues suggests a pretty intensive review. But the great modern question is, I think, is it always that intensive? In FAM against the Secretary of State for the Home Department, we were dealing with the removal of nationality, which we concluded was a pretty basic right to be a British national. If your nationality is removed, it's pretty fundamental. And we quoted what I think are wise words originating from an authentic source, and that is Professor Dr. Gertrude Lübbe-Wolf, who was a former judge of the Bundesverfassungsgericht, which is the German Federal Constitutional Court, which is, after all, the court which originated the term proportionality. And she said that proportionality is no more than a tool directing attention to different aspects of what is implied in any rational assessment of the reasonableness of a restriction. It is a rationalizing heuristic tool, and whether it is used as a tool to intensify judicial control of the state acts is not determined by the structure of the test, but by the degree of judicial restraint practiced in applying it. So there is scope, considerable scope for argument about how intensive the review should be, and I think you can, if you ask where that fits, say that it fits within the fourth element of fair balance, the institutional respect you give to decision makers in certain contexts. Now, what we have seen, I think, is also the gradual emergence of proportionality as relevant in the common law. Lord Diplock himself, in fact, foresaw that that might be the case, but in recent jurisprudence, we have taken up the baton and with some variation in theme between different judges, we have endorsed the relevance of proportionality in the common law, in particular, of course, in areas where you could speak of basic common law rights. In Kennedy and Charities Commission, we noted that Professor Paul Craig had shown the way in the sense that analysing a lot of common law cases ostensibly decided under the Wednesbury principle, he suggested that in reality they showed a considerable degree of proportionality type reasoning, and we commended the advantage of the terminology of proportionality in introducing an element of structure into the exercise by directing attention to factors such as suitability or appropriateness, necessity, and the balance or imbalance of benefits and disadvantages. I have to say that it's not always possible to draw such a balance. In a recent case dealing with minimum pricing by the devolved Parliament in Edinburgh, the law was challenged in front of us, and it was challenged actually primarily under European law on the grounds that minimum pricing of alcohol in Scotland would affect the internal market of the European Union. Wines such as Italian and Bulgarian would not find so ready a market, and so on. There were some quite interesting statistics as to which countries might in fact suffer. But leaving that aside, the answer was that under European law, the member states have the prerogative to derogate from the principles governing the internal market in the interests of public health. And I personally found that a totally incommensurate balance, which it was in fact impossible to strike. How do you measure the value of a saving of 100 or even a dozen lives through minimum pricing against the effect on the internal market of the European Union, Bulgarian, Italian wine cellars? And in the end, we said that these were not really sensibly measurable against each other, and that the health exception must, in that context, dominate. So the decision of the Scottish Parliament was upheld, and we shall see in a few years' time what effects it's had on health in Scotland. The statistics in that respect were also extremely sad, and one hopes that it does have an effect. The case of FAM also points out that it's outside the area of basic rights, where I think in common law proportionality has effectively superseded the Wednesbury test of rationality. It's not easy to say quite how far the concept will emerge as a dominant test. I don't think it can be said, perhaps despite some rather wide dicta of my own, that it is across the range the test, and despite what Professor Paul Craig has said about the tacit deployment of the Wednesbury test in a sense which has nothing to do with red hair. Now, some principles are undoubtedly more basic, and some are more susceptible of judicial protection than others. There's an obvious spectrum. At one end, courts identify and strive to control excessive power in core areas like personal liberty, inhuman treatment, or freedom of speech or expression. At another, they recognise the greater institutional competence of the executive in policy decisions involving, for example, the raising and deployment of scarce resources. In the case of unison, which I mentioned a moment ago, these considerations might be seen as competing. That case involved a decision by the Lord Chancellor to set employment tribunal court fees. Actually, for the first time, I think the employment tribunal was effectively free of access, so as to recover full tribunal costs. The effects were somewhat remarkable, in particular in comparison with ordinary county court civil costs. Suddenly employment employees seeking to pursue their present or former employers found themselves facing fees far heavier than those which a county court litigant would have faced for similar value litigation. We refused to analyse this in terms of a case about the raising and deployment of scarce resources. We said that justice should not be treated as a commodity. What was at issue here was a constitutional right of access to justice, and we struck down the fees regulations as unfairly deterrent and arbitrary in their effect. The decision has been interestingly criticised by a former law commissioner in an article on the grounds that this didn't give sufficient weight to the government's role in controlling court costs. But I think we made a fundamental and important point that justice is a general good which benefits society at large, and it cannot simply be seen as a bargain or a benefit as between litigants. On the contrary, it gives guidance to society at large and avoids litigation for the benefit of a lot of other people. Well, I have mentioned a spectrum. At a very opposite end of the spectrum, courts do sometimes withdraw from review of executive action altogether. But I have to say the areas where we do so continue to shrink, and where we do it once again by choice, not because the legislature or the executive wishes it. There are a lot of choices in this area. The balancing exercise is, I think, very interesting, but of course it differentiates public law from, in most cases, very significantly from black letter private law, where you can rest comfortably in the intellectual analysis, which hopefully leads to a clear solution about which you don't need to worry in quite the same way as you do when you are balancing competing interests, whether they're public or private, in a public law context. The public law context is preeminently one where judges may differ about the weight to be given to different factors. What weight do you give institutionally to the judgment of ministers or civil servants? When is it that judges can be said to be better placed? Core areas we recognise, like liberty, but there are many areas where the matter is less clear. Sir Philip Sales, in a recent article, he's soon to join the Supreme Court in the United Kingdom, suggests that judges should be looking for and focusing on rights which Parliament must itself be taken to have accepted, and presumably judges must be giving them the weight which Parliament itself must be taken to have accepted. Well, that sits very neatly within English traditions of parliamentary supremacy, but I think it fails to reflect the judicial role today as an independent pillar, reflecting not just Parliament's view, but the best values of society as a whole. And a lot of the point of judging is that sometimes Parliament hasn't really thought about things fully, and indeed sometimes it's very often one finds it welcomes a certain degree of judicial creativity to avoid having to go back to Parliament and seek some fresh measure to correct an obvious inequity. I certainly think that it is wrong to say there's a correct answer in many cases. I hope that in most cases we agree, but part of the virtues of a successful appellate system and jurisdiction is, of course, to synthesize differences and to identify them where they can't be reconciled. Just let me mention very briefly, I've touched on the area of institutional competence in relation in particular to unison, but we had another interesting example in the context of assisted dying in two cases, Purdy and Nicholson, where the law contains an absolute prohibition of assisting suicide, with which we haven't interfered. We've said that at any rate for the moment, Parliament is the parliamentary legislation stands. In fact, there's another case coming to us now, so I won't say any more. But what we also said was that the prosecution authorities should address the question as to when they would prosecute. In other words, the absolute prohibition doesn't mean to say that everybody should be or is going to be prosecuted. So how do you know what the position is? And should there be not some indication as to how the Director of Public Prosecutions is exercising his discretion? And in Purdy, we said yes, there should be. In Nicholson, we had to consider the question, well, precisely what does that mean? Because by then the DPP had actually issued guidelines, and a litigant came to us and said, well, I actually want to be able to tell by reference to these guidelines precisely whether I'm going to be prosecuted if I act as follows: take my relative to Dignitas in Switzerland, where their lives will be ended. And we said effectively that wasn't the judicial role to say that. The reason for the guidelines was to give an indication as to the factors which the Director of Public Prosecutions would take into account in exercising his or her discretion. It wasn't to effectively amend the law by saying in the following circumstances you will be criminally pursued and in the following you won't. It was to ensure consistency, identify the factors, but it would not be constitutionally appropriate to dictate to the DPP such precision that everybody should know precisely where they stood. The guidance was not guidance in that sense. The second area I wanted to mention very briefly is perhaps overlaps the two papers which I referred to, namely relations between judiciary and executive and relations between the judiciary and the legislature. And that is legislative attempts to restrict judicial review of executive action. What I think are called in Australia privative clauses, commonly called, I think, ouster clauses in the UK, and as Mark Elliott has written, clauses which raise the most delicate of constitutional issues. The foundational decisions in this area are again Lord Diplock, I think truly astonishing decisions when one reads them, dating in the first case from 1969, Anna's Minnick, and then that was buttressed in Re Racal Communications in 1981. In Anna's Minnick, the case concerned the decision of the Foreign Compensation Commission under the Foreign Compensation Act 1950, which, as then enacted, provided that the determination by the Commission of any application made to them under this Act shall not be called in question in any court of law. What the House of Lords under Lord Diplock ingeniously did was interpret determination as embracing only valid determinations. Well, perhaps that's not so radical, but they then enlarged the concept of error of law. They moved the goalposts effectively to the corner flags, so that the concept of error of law was not just an error of law relating to jurisdiction, but it included any error of law, including also a failure to follow a prescribed or a fair procedure, so that if effectively there was any error, the determination would be regarded as invalid and the clause simply wouldn't bite. I'm not sure what content that left the clause, but anyway, it was extremely ingenious and rather effective. The legislature and or executive have unsurprisingly looked for even more complete formulations which would preclude that approach. Well, in a constitutional state like Australia, that wouldn't be permitted. I think the case is Plaintiff S157/200 against Commonwealth in 2003, and in Canada it wouldn't be permitted. The privative clause would simply be treated as indicating that there should be a high degree of institutional respect for the decision maker. But in theory, in the United Kingdom, it could be binding because of the doctrine of parliamentary supremacy. But I think if the legislature and the executive were to try too hard to exclude judicial review in this area, the right result might just conceivably be the opposite of what they intended. It might actually trigger in the United Kingdom a true Marbury and Madison moment based on a fundamental constitutional principle of the common law. In 2004, the government proposed to include in an asylum and immigration bill a clause removing the power of judicial review of the new tribunal being set up. And Lord Woolf, who was then Lord Chief Justice, spoke powerfully in an F.A. Mann lecture, great international lawyer, Dr. Mann, against that, and said one of the twin principles on which the rule of law depends is the supremacy of Parliament in its judicial capacity. The other principle is that the courts are the final arbiters as to the interpretation and application of the law. And Parliament actually, the executive actually backed down in its attempt to introduce that clause. And there have been quite a number of dicta in the United Kingdom to the like effect in case law to Lord Woolf. In New Zealand, Sir Robin Cook has been foremost. In Australia, in Mom Chilovic against the Queen, I see that Justices, Chief Justice French and Justices Crennan, and as she then was, Kiefel, were referred to the point. And in Jackson against the Attorney General in the UK, the Hunting Act case, there are dicta from several of the judges. Again, I think words of Lord Reid, speaking for all of us in unison against the Lord Chancellor, are pertinent. He said, the constitutional right of access to the courts is inherent in the rule of law. Courts exist in order to ensure that the laws made by Parliament and the common law created by the courts themselves are applied and enforced. Without such access, laws are liable to become a dead letter. The work done by Parliament may be rendered nugatory, and the democratic election of members of Parliament may become a meaningless charade. In summary, I think what he was hinting was that the position may be that law effectively ceases to be law unless you have access to a superior court to establish and ensure its proper and uniform interpretation. I won't say more because, in fact, interestingly and curiously, there is a case which is coming to the Supreme Court, Privacy International against the Investigatory Powers Tribunal, where the point is raised. There, the government added to the legislation, the regulation, I think, no, it's the legislation, a clause saying not only that decisions of the tribunal were not subject to appeal or liable to be questioned in any court, but also decisions as to whether they have jurisdiction. Now, that may have been intended, I think, directly to counter Anna's Minnick. If so, it's going to be challenged. The courts below, with one doubter, have upheld it and said there can't be any review of the Investigatory Powers Tribunal, which of course deals with very sensitive matters of surveillance. But we've given permission to appeal. We've allowed 2 days for the appeal and may well decide to sit with more than 5 justices. Finally, time is short. Let me very briefly just identify, because it's interesting, the third area where courts don't tread at all, and shouldn't, by their own choice, as I've said. This, of course, is within the framework of the area of prerogative, and in particular, act of state. One has to say that since the area of immune executive prerogative has been steadily diminishing, like it occurred to me, Hong Kong Harbour, over the years, the GCHQ case in 1984 saw the end of an era when prerogative powers were generally thought of as immune from judicial review. But even then, since then, the short list of powers which where there might be some immunity has been steadily qualified. If you just take foreign policy generally, courts have required the Foreign Office to make representations about British subjects held in Guantanamo, or consider doing so further. Courts have reviewed the expression of a view of a member of the civil service who was sitting on the Security Council's Sanctions Committee. Courts have reviewed a decision not to give legal aid for an appeal by a British citizen convicted abroad of drug smuggling. And in the recent Brexit or Article 50 or Gina Miller case, even the prerogative power to make and unmake treaties was held reviewable because of the direct domestic effect which leaving the European Union would entail. That probably, though, is, it depends how you analyse it, but it may be analysed actually as a case on legality, I think. On act of state, a slippery doctrine, as Dr. Mann once said. We've had some very interesting cases where we have actually accepted that certain acts abroad by the state in the exercise of sovereign, usually military power, with the prior authority or ratification of the Crown, and in the conduct of relations with other states or their subjects, may be or are immune from review in a domestic court. In particular, the detention in the case of Rahmatullah of suspected insurgents in the course of armed conflicts in Iraq and Afghanistan. But act of state otherwise is not a popular doctrine. We firmly rejected its application in a case where what was relied on was not the British state's own act of state, but it was said that you would be reviewing foreign acts of state, and that's Belhage against Jack Straw, the former Foreign Secretary, where the British government was accused of instigating and conniving in providing information to enable illegal rendition, effectively kidnapping in Malaysia and Thailand, removal via the Chagos on an American airplane of two Libyans back to tender care of Colonel Gaddafi, where they were tortured and detained. They, after Gaddafi fell, sued various emanations of the British state and the Foreign Secretary and the head of the Secret Service and so on, and said that they were liable in damages. We rejected that. We said that the mere fact that we would be adjudicating upon a foreign state's conduct didn't give rise to any immunity. This was a case of kidnapping and torture, which had long been illegal since Magna Carta, etc., and there were judicial and manageable standards with which to address it. And in fact, the British government has, after that decision, now settled the case with an apology, which was all that Mr. Belhage wanted, and £500,000 to his pregnant wife, who was also kidnapped and tortured. We did speculate a little as to whether there were any circumstances when the conduct of a foreign state might not be justiciable, and we floated a few ideas about drone strikes with British intelligence assistance. We were urged not to say very much about that. So we didn't. I think I will leave it there. One can draw some conclusions, but perhaps they can be done in argument. Thank you very much indeed.
Thank you, Lord Mance, for absolutely splendid start to the conference, thoughtful and witty exploration and a very diverse range of cases, the tension and the complementarity between executive and judicial power. I thought you articulated very well the fundamental and important values of the legal system, but the complexity and challenges of applying those in actual cases, including cases where you may have incommensurate values, cases where institutional competency is at stake, and so forth. So thank you for that really interesting and stimulating start. Our second speaker tonight is another very distinguished barrister and long-serving judge, the Honourable Mr Kenneth Hayne. Mr Hayne will be known to many of the lawyers in the room as a long-serving justice of the High Court, involved in many of its most critical decisions in recent years. He has found, though, even wider public fame in retirement in his role as Commissioner of the Financial Services Royal Commission. He'll speak tonight on keeping pace with the changes in the use of executive power. Please welcome him.
Thank you very much, Carolyn. A subject as wide as the frontiers of executive power demands really attention to some very basic questions. And the most basic question is whether public law doctrines have kept pace with changes in the ways in which executive power is used. Last year, when I was serving as an old age pensioner in retirement, and I had begun to write this paper with a view to making a proper presentation at this conference, I had intended to draw attention to three kinds of change where I thought the question of keeping pace may arise. First is that the political branches of government have looked more and more to the market economy as a model for providing services to society. The second subject was that legislation has been enacted to establish numerous authorities, more or less independent of the political branches of government, to regulate particular industries or activities. The third subject was that governments and regulators have sought to modify behaviour by promulgating soft law, guidelines, codes of conduct, prosecutorial guidelines of the kind that Lord Mance mentioned, and the like, rather than black letter legislation. Events then, as you have heard, overtook that intention, because I am now in the middle of a Royal Commission and my terms of reference require me to inquire into and report about matters that touch directly on the last two subjects, regulatory authorities and soft law. So all I do tonight is suggest that these are subjects that you may think are ripe for further consideration and say no more about them. Instead, let me say something about the issues that arise, I think, from the political branches looking to the market economy as the model for providing public services. For the most part, this is done by making a contract that will oblige a private counterparty to supply services to the public generally, such as a toll road, or to a section of the public. The example of a section of the public I prefer always to use is the provision of a private prison. And when a contract of that kind is made, there are at least three kinds of issue which emerge. First, which organs of government must be engaged to create the obligations? Second, how transparent are to be the processes for negotiating and then administering the arrangement that is made? And third, who is to be accountable for the arrangements that are made and for their performance? Now, how any of those issues intersect with accepted notions about governmental structures and about judicial review of administrative action depend, of course, first upon what those notions are and whether and to what extent they are developments that suggest that public law doctrines should change, will necessarily lead on into consideration of questions about standing to sue, about grounds for challenge, about what relief may be given, to whom it may be given, when it may be given. All of those questions would emerge and appear on the table. But I think that the making and administration of a contract with a private counterparty for the provision of public services intersects with basic questions about governmental structures, because it is necessary to consider which organs of government must participate in its making and administration, as well as what power there is to make the contract. Now, Australian public lawyers are very well used to notions of separation of powers. They're very well used to drawing distinctions, at least at the national level of government, between legislative power, executive power, judicial power. They are very well used to thinking of the duty and jurisdiction of courts to review administrative action as not going beyond the declaration and enforcement of the law, determining the limits and governing the exercise of the repository's power. And the chief focus of Australian notions of separation of powers seems always to have been upon the distinctive features of the judicial power of the Commonwealth, dealt with in Chapter 3 of the Constitution. But behind the conclusions which have been reached about judicial power lie conceptions of separation of powers, which find their roots in the observation that the Australian Constitution, like the US instrument, deals separately with the three species of power: legislative power of the Commonwealth, executive power of the Commonwealth, judicial power of the Commonwealth. And yet, unlike the US Constitution, the Australian Constitution establishes a system of responsible and representative government. Hence, the separation of legislative and executive powers effected by the Constitution both permits and requires that some who exercise executive power, ministers of state, will participate in the exercise of legislative power and are to be answerable to the federal parliament. So the Australian separation of powers may then appear to present a conundrum. But if it does, the solution has two parts. First, the division effected between the three species of power is a division of powers whose character is determined according to traditional British conceptions. And second, the division does not depend upon fundamental functional differences, so much as upon distinctions generally accepted at the time the Constitution was framed between classes of power requiring different professional skills and habits in the authorities entrusted with their exercise. The second point to note about the Constitution is, of course, that it gives the High Court an entrenched jurisdiction to grant certain kinds of relief against officers of the Commonwealth. And the relevant section of the Constitution, section 75(5), is treated as providing an entrenched minimum provision of judicial review. But as it has developed, the central concern of judicial review of administrative action, whether under 75(5) or more generally, is still seen in Australia as being to enforce the legal limits on the exercise of public power. And it follows then that the focus of proceedings brought under 75(5), as well as non-statutory judicial review more generally, is upon identification of those limits, both constitutional limits to power and express or implicit limits on the exercise of statutory power. But despite familiarity with those ideas about judicial review, Australian lawyers have not often engaged in any fundamental examination of the nature or the extent of executive power. Judicial review of administrative action has predominantly focused upon constitutional or statutory limits on the power rather than on any consideration of limits deriving from constitutional or governmental structure. And to the extent to which attention is given to the nature of executive power, it is often by reference to traditional conceptions of that power. And those traditional conceptions were formed in other times. They were formed before the more recent and the more novel exercises of executive power. And as we all know, both in Australia and elsewhere, the ways in which the management of the affairs of the body politic is effected have changed in recent decades. At the national level in Australia, conducting foreign affairs by the sending and receiving of embassies, securing protection of the nation and executing the law, those three traditional ideas in executive power, remain central to the exercise of executive power. Yes, of course they do. But what has changed is the extent to which and the means by which other aspects of the affairs of the Australian bodies politic, both national and state, are managed. As I said at the outset, more and more the governments of Australia have looked to trading and financial corporations as the model for management of those affairs. And there has therefore followed the blizzard of corporatisation, followed by privatisation, with which we are all familiar. Disposing of the rights and assets associated with provision of services to the public has usually been driven by maximising return to government, while at the same time shifting responsibility for the quality of the services provided from government to the private sector operator. The terms on which private sector operators acquired the right to provide the services have often been kept confidential. In some cases, government has sought to increase its return by giving the private counterparty a preferred position in the relevant market for a period extending well beyond the life of the administration which makes the arrangement. And in some cases, most notably what have come to be called market-led proposals or unsolicited offers to government, the processes by which private sector operators acquire rights or acquire assets from government are kept confidential. The mantra, commercial in confidence, is increasingly treated as a complete answer to any call for public revelation of or debate about the terms on which the transactions are effected. Now, all three features, outsourcing, maximisation of returns, opacity of process, provoke consideration of what is the role of executive government. More particularly, they invite attention to whether and when arrangements which the political executive conclude are for the better arrangement of the affairs of the polity can be effected by the exercise of executive power alone or require some express legislative authority. That is, they are issues that direct attention to consideration of structures of government and which organs of government must be engaged to effect certain arrangements. Too often, I think, the answer which is made to the issues is to say no more than that The contracts made are Crown contracts or contracts made in the exercise of some non-statutory executive power. And neither form of answer grapples with the issues that lie behind them. Each is little more than the ritual incantation of a slogan. I have sought to explain elsewhere, I think, that references to the Crown and its capacities in this field of discourse distracts attention from the issues that arise when a body politic makes a contract. To answer those issues by saying only that the contract is made by or in the name of the Crown, it is to be enforced in accordance with Crown Suits Acts, the Crown has the powers and capacities of a natural person, therefore the contract is valid, slides over fundamental issues. Does that in at least two ways. First and foremost, the Crown is an ambiguous metaphor. In Australian constitutional law, the relevant right and duty-bearing entity is the polity called into being by the Constitution, the Commonwealth. Or it is one of the states identified in covering Clause 6 as a distinct body politic. The executive is not a right and duty-bearing entity. And second, observing that a polity, or the Crown, has capacity to make a contract does not show that the executive of that polity has power to make all kinds of contract on behalf of the polity. An observation about capacity says only that there is capacity to contract. It says nothing about whether any particular contract is made within power. And that is a question that requires consideration not only of subject matter limits on power, but also of what organs must be engaged. I say in the written paper something about what has emerged from the writings in the Supreme Court of the United Kingdom about the Crown possessing general administrative powers to carry on the ordinary business of government. And the fact that the notion of general administrative powers is an idea that has struggled, I think, in some respects to find a satisfactory juridical foundation or content. But let me pass by that and say that in Australia, at least, questions of general administrative powers of the Crown are resolved expressly, to the extent that Section 64 of the Constitution gives power on the ministers of state to administer the departments of state. And that power carries with it all that is necessarily incidental to it. One of the things that is obviously necessarily incidental to that power to administer is the power to make contracts for the administration of the departments of state. Most in this room will be familiar with the fact that at some time after 1945, it came to be fashionable in Whitehall to say that a minister may do anything that a natural person can do unless limited by legislation. The view was said to stem from a memorandum by Sir Granville Ram, and it came to be known as the Ram Doctrine. But as Adam Tompkins has demonstrated, Ram's memorandum neither asserted nor supported the view attributed to it. The view, the so-called doctrine, has now been, I think, rightly discredited. I mention it for this reason. If a minister standing at the apex of administration of a Department of State does not have general power of the kind asserted, why would it be supposed that the permanent head of the department or some more junior officer in the executive would? Yet it is an assertion of that kind, an assertion of the kind made by the Ram Doctrine, that lies beneath the proposition that the executive has general power without statutory authority or approval to make contracts not for the administration of a Department of State, but which nonetheless bind the polity. So let me return to where I began. Are our ideas about executive power keeping up with new and different ways in which executive power is being used? More and more often, governments are resorting to executive power to make contracts for provision of services to the public. Too often, lawyers look at those arrangements only through the lens of the law of contract. But if we look at them through the lens of public law principles, do we not need to ask whether those principles have kept pace with this change? Or is our thinking confined by habits of thought and argument formed in other times and in other circumstances? Too often we're creatures of habit. Too often we apply old rules to new circumstances without pausing to think whether it is right. Thank you.
Well, thank you, Mr. Hayne. Another really terrific speech. And a conference like this one is about asking the big, challenging questions, and the question that you both started and ended with, whether our concepts of executive power, whether we be members of the legal profession, the judiciary or the academy, have they kept up with the really quite substantial changes in the way in which executive power is in fact exercised? And the particular question of the intersection between contract and private providers and executive power is a particularly fascinating one, and I think we all look forward to the day when you are free to answer the other two questions that you referred to as well. I suspect that may not be for a little while. Now, because both of the speakers have been exemplary, and I use the word advisedly for the rest of you who will be speaking across the course of the conference, in keeping to the time that has been allotted to them, we have about 20 minutes for questions. In order to allow as many people as possible to ask questions, I will ask you to wait. This won't help many people to ask questions, but could you please wait for the microphones because this is being recorded? Could you please state your name and any affiliation that you might have? And could you keep your questions reasonably brief questions rather than lengthy speeches finished with, so what do you think? If you're struggling with that concept, I will assist you. So could we have a show of hands for anybody who'd like to? I think we've got some. Sorry, if you could just wait for the microphone for a moment, it's coming.
Hi, I'm Margit Kohn from the Hebrew University of Jerusalem. Thank you very much for two fascinating speeches. What I would like to ask is about your assessment of whether the changes that we see in the decision-making process, the redrawing of the state in Australia, obviously in other countries, has it made any changes in the relative dominance of the executive or the head of the executive? In the case of outsourcing, etc., there's this rise, or so people say, the rise of regulation, which you are happy to be involved with, I hope. So does it really make any difference in the fact that the body that makes the decision, both in the UK and in Australia and elsewhere, remains the executive? It's the shape of things have changed, but whether there has been sort of a more major change in the relative power of the executive. Thanks.
Short answer, I think, is yes, there has been a change. I think the executive is, paradoxically, by doing less, by outsourcing, is in truth doing more.
My answer would be that the response of public law over the last 40 years, I think, has been because of the growth of executive power, in particular what you referred to, the rise of regulation, often under the guise of subordinate legislation, which needed a response. Of course, all the arguments that I mentioned arise every time we are invited to consider, for example, some piece of social regulation restricting benefits here or there. We then find ourselves faced with a whole welter of information about indirect economic compensating factors and other pieces of social legislation. So there's no doubt about the difficulty of the task, but I believe that courts have embarked on it to a greater extent for the reason you mentioned.
Gentleman up there.
Joshua Getzler, Oxford. We had the bank charges cases in Britain and Australia. We now have a big credit card charges case in UK. But there have been very few cases prosecuting or disciplining in courts bankers and financiers who wrecked the Anglo-American financial systems. Is it a policy or a legal question whether the SEC, as Judge Rakoff observed, should not have avoided prosecutions of financial miscreants, but have done the whole thing by fireside chats, fines, payments by banks, with absolutely no discipline in court to set standards for the future? Is this a policy problem or a legal problem?
Might have to wait for one answer to that question.
I think it's both. I mean, the policy is obvious, namely that it's easier by extra criminal means to get some sort of result. The legal problem is that we are not providing, evidently, an easy means of dealing with some criminal offending. As a matter of interest, although again it's been criticised, but as a matter of interest, the government and the City of London have just agreed to build an entirely new court near the Temple, but in the City of London, in order to address exactly the sort of offending you're mentioning. The criticism is, of course, that access to justice in other parts of the system is deficient. Legal aid has been reduced, and spending millions on that sort of offending can be said again to be disproportionate, a difficult balance, I'm afraid. But I mean, I fully understand why non-criminal means are taken, because they are more easily effective, even though it's a lesser effect. But we do need to improve the criminal prosecution of serious cases. I accept that too.
I think Justice Hayne will take that as a comment, or
My answer, Joshua, is very simple. If you could let me have something in publishable form, my time for final report is 1st February next year. I'd be much obliged.
other questions?
One up.
There's one there, and then Justice Hayne.
Mike Waite, Crown Solicitor of South Australia. I have a question for Mr. Hayne. I find your discussion very fascinating about the source of executive power to contract. My question, in a sense, is moving on to the next stage. If we start looking at amenability of government contracts to review, and my question is whether you consider that government contracts would be reviewable on sort of grounds that might be traditional grounds of judicial review. So I suppose my question is whether a government contract could be reviewed, for example, because a court might consider that entry into the contract was unreasonable in a sort of policy setting, or whether the contract could be reviewable because the government hadn't given procedural fairness to perhaps competitors in the marketplace and so on. So I just sort of wonder if, and I might be getting too far ahead of myself in that I don't know really what you say about amenability at all, but if we get to that step, what the principles might be that would apply to assessing government contracts.
Well, but for the fact that events overtook litigation emerging from your state in Aquista and the Development Authority, I think, was the opposite party, we might have had the advantage of some views from the High Court of Australia about whether the making of a contract was, or the grant of public land, I think, was the central piece of property in Aquista, whether that was reviewable on Wednesbury unreasonableness grounds. Justice Bell, in the full court, in dissent, I think I'm right in remembering, said that it was. The question you ask, I think, is important. I am much less fussed about knowing what answer is to be given to that question than I am about the need to ask the question and think about it. These are questions which deserve proper, thoughtful consideration. They are not questions that I think admit only of one answer. And as I say, I am much more fussed that people think about it than I am about what answers they arrive at, so long always as the answer is one which has been thought about and is defensible. So there is a whole set of questions of the kind that you raise. I commend their being asked and their being answered.
And then just if you want to move.
Thank you. Tim Ganane, Victorian Supreme Court. Could I ask primarily Commissioner Hayne a question that may be answered by the previous answer, but the commercialisation and contracting out of basic services such as provision of electricity, gas, things like that, on one view gives the consumer no real right to enforce by traditional judicial review remedies their rights to the proper provision of those services. They may be able to go to ombudsman or complaint services or things like that. But in the days when statutory authorities or local councils provided such services, the books are full of cases where the defendant will be the electricity commissioners, the water board, things like that, and judicial review loomed large in ensuring not just that the original arrangement was valid, but the actual performance of the contract was carried out. Does the landscape that's been described really mean that the consumer has no real legal right in respect of these commercial contracts because the consumer is not a party to the contract and presumably has no standing in court to enforce provision of services, whether they be electricity, gas, telephone services, NBN, all those sort of things? They would not be able to sue in court, whereas in the old days they may have had some remedy against a statutory body or a minister who was susceptible to traditional judicial review remedies or prerogative writs.
Well, Tim, I think there are at least two questions wrapped up in that. There are probably many more, but can the consumer complain about, for example, the setting of standards by government? is the private citizen to be able to say to government, you have made a contract with XY Co for provision of public transport, and you have set the standard to be met as being that you provide one bus service to Bandywallop South once each Pancake Tuesday. That was the kind of decision that you as government should not make for want of a consideration of relevant factors, and here follows a litany of ordinary public law complaints. Put that in contrast with the customer who says, my bus didn't arrive on time. I want to sue someone about the fact that my bus didn't arrive on time. I'm much less fussed by that kind of complaint than I am about the lack of process for accountability for decisions that are made about the ways in which public services will be provided. Now, we have to accommodate the fact that the role of government has changed. There is no clearer demonstration of that than to read the Australian Constitution with its reference to state railways, gone, state banks, gone, state insurance, gone. The role of government has changed, but are there elements in the processes that are now used to provide services to the public at large, or to sufficiently large sections of public, which warrant the kinds of scrutiny that hitherto we have applied only to the exercise of public power? Now, again, I don't know what the answer is. And again, it's a subject where I am less fussed by the answer than I am about the need to ask the question and not fall back on, oh, well, private contract, no remedy lies. Maybe that's the right answer to get to, but there are several intermediate steps.
I think we have time for one final question at the front here.
Stephen Donoghue, I'm the Commonwealth Solicitor General. My question's for you, Lord Mance. A number of the examples that you gave in your speech hinted at the kind of material that's being put before the Supreme Court in public law cases as the factual foundation for the kinds of intense proportionality analysis that you were speaking of. And I wondered if you could, that's striking to an Australian audience because it sounds like it takes the court into an evaluation of the merits of a policy in a way that is less familiar to us. And I wondered if you could offer any observations about the way the court is informed of the competing merits of these policies and the nature of an extent of the material that is given to you, and whether it you feel, or the extent to which it equips the court to engage in the kinds of questions that kind of analysis throws up.
And I think that's a very interesting question, and probably best answered by taking the other aspect of Nicholson, the case about assisted suicide, which I didn't really focus on, not the discretionary prosecution element, but the basic question, whether the law was itself proportionate. In that case, we were given a large amount of secondary material which had been culled from a first instance decision in Canada, in Carter, on a similar point. And I certainly emphasised in my judgment that I thought that was not an appropriate basis for putting the matter before us. Now, I think I said that in principle this was a matter which was reviewable. In principle, it was much better decided in Parliament. Parliament was actually showing an interest in considering the matter. There was a bill being put before it by Lord Faulkner relating to terminally ill people. Nicholson was about people with locked-in syndrome. And I think a majority of us, or a larger part of the majority, felt that in those circumstances it just wasn't appropriate at that time for a court to intervene, but held open the possibility that a court might intervene. There are some, Lord Reid was one, I think Lord Sumption too, who would simply take the view that even if the evidence had been there, this wasn't the court's function. This was a matter which was so preeminently one of moral and social judgment that however many facts you had about the risks of, for example, people being persuaded to commit assisted suicide, people persuading themselves out of false guilt that they were a burden on their relatives, that they should commit assisted suicide. That however many statistics you had about that, it's a very difficult area to get statistics on, you were faced with an impossible evaluation because you come back to a similar point to the one that I mentioned in relation to the Scots alcohol case. What is the value of a human life? I mean, some people would say if one person was at risk, that was too big a risk. On the other hand, the life of someone with locked-in syndrome is intolerable. You might think that the life of someone who's going to die shortly, well, maybe that's not such a clear case, although it's funny enough a case on which the most focus has been. So I think these are very difficult factors on which different people have different philosophical outlooks. I think the Court of Appeal, when the matter came back before it in the different Nicholson case that I briefly mentioned, simply took a line rather similar to the Lord Reid line, namely, look, Parliament has now considered it, Parliament has decided not to change the law, and a court shouldn't intervene then. But subject to that, I mean, take less controversial areas, the social security areas, social benefits areas. If you're not giving social benefits to an unmarried couple, is that something where a court should intervene when there's actually evidence of other benefits available to them? Again, some people would say, well, ultimately this is a matter of swings and roundabouts. Some people may suffer in one situation, some may be worse off. Really, courts shouldn't get engaged in this micromanagement. But I think very often we do actually identify the big point, which is discrimination between married and unmarried people, and say it would be much simpler if you treated couples who are in a similar position for relevant purposes as similar, and didn't ask us to engage in this complicated balancing, i.e. the simple legal principle may sometimes prevail over a lot of statistics. But it's a very interesting question.
Ladies and gentlemen, I think we've been very fortunate tonight to have two such generous speakers. They've been generous in the time, the effort and the thoughtfulness that they've put into their papers, and also their willingness to answer some very interesting and pertinent questions. They've given us a lot of food for thought. It's a great way to open this conference. I'm sure some of the themes that they have opened up tonight will be returned to many times. In addition to the food for thought, we have more standard food, which will be available back up on level 1 where you were before, so there'll be a buffet dinner there now for the next couple of hours. People are very welcome to join us for that, but before we do, could you please join with me once again thanking our two speakers.